Hello everyone. My name is Tanmay Saha, pursuing BLLB honors from Bengal Law College, which is affiliated to University of Bardhaman at West Bengal. I will going to discuss the topic, which is Talaq under Muslim law. Let's get started. I'm starting with introduction. For understanding the method of dissolution of marriage, let's first see what is marriage under Muslim law. Because the only essential for divorce under Muslim law is marriage. The dissolution of marriage, also known as divorce. Different religions define marriage differently, such as according to the Hindu Marriage Act 1955, marriage is a religious sacrament. Under Muslim law, marriage is a contractual relationship between two parties. All the essentials that are required for a contract are present under Muslim marriage. There is an offer, acceptance, consent, consideration, the capacity of the parties, etc. The purpose of such a form of marriage are legalizing the sexual intercourse and procreation of child. Divorce is the end of such a marital relationship. As under Muslim law, there are two modes given for the dissolution of marriage: divorce and talaq. In daily life, these two terms are alternatively used. But under Muslim law, if a person seeks divorce, he will be governed by the provision of the Dissolution of Muslim Marriage Act 1939, whereas talaq proceedings are governed by the Muslim personal law. Next, there is a chart, classification of dissolution of marriage. Classification of dissolution of marriage can be done by the date of either party to the marriage or by divorce. By divorce, there is a by husband, by wife, by mutual consent, by judicial decree of dissolution of marriage act. By husband there are three grounds: talaq ila jihar. Talaq can be divided into two categories: talaqul biddat, talaqul sunnat. Talaqul sunnat divided into two categories: Hasan and Hasan. Talaqul biddat, written talaq, triple talaq. By husband there is a ground is called talaqul tawfiz, and by mutual consent there are two grounds: khula mubarat, and here the lian and fox. Let's discuss one by one. By divorce by husband, the husband can divorce his wife using three methods of divorce. There is a first, which is talaq. A Muslim husband can give talaq to his wife any time during their marriage with the intention of dissolving the marriage. All the conditions are to be fulfilled by the husband at the time of the pronouncing the divorce. The talaq further divided into two modes, which are talaqul sunnat. This form of talaq is considered to be the most acceptable form of talaq because the divorce doesn't become final when talaq is pronounced, and there is always a possibility to compromise and reunite. This form of talaq is recognized by the both Sunnis and Shias. It is talaq which is effected in accordance with the tradition of prophets. This talaq is further classified into two types: this Hasan, which is most approved mode of talaq. The Arabic word Hasan means best, or as put it very proper. This signifies that the talaq pronounced in the Hasan form is very best kind of talaq. Hasan talaq must satisfy this condition: the husband must pronounce the formula of divorce in a single sentence. The pronouncement of divorce must be in a state of purity, is a tuhar. A tuhar is a period when a woman is free from her menstrual course. He must abstain from intercourse for the period of iddat. Next, Hasan. It is also known as the good mode of talaq. In Arabic, Hasan means good. It translates also known as proper. To be in Hasan talaq, this condition must satisfy: there must be three successive pronouncements of the formula of divorce. In the case of the menstruating wife, the first pronouncement should be made during a period of tuhar, the second during the next tuhar, and the third during the succeeding tuhar. In the case of the non-menstruating wife, the pronouncement should be made during the successive intervals of 30 days. No sexual intercourse should take place during these three periods of tuhar. This is talaq. Next one is talaqul biddat. Unlike the Talaqul Sunnat, this form of talaq is entirely different. This is popularly known as the triple talaq. Here the talaq is pronounced 3 times in a single go at once or in a single breath, which is irrevocable. The Apex Court banned the practice of triple talaq in the case of the Sahara Bano vs. Union of India in 2017. The second kind of talaq is the ila, or it is also known as a vow of continence. So, in this talaq, where a husband had attained majority and is of sound mind, swears by God that he will not have sexual intercourse with his wife and leave the wife to observe iddat, that he is said to make ilah. Where the husband, having made ilah, abstain from intercourse with his wife for 4 months, the marriage is dissolved. So essential of ilah are: the husband must be of sound mind and must have attained majority. He swears by God or take a vow that he will not have sexual intercourse with his wife, and in pursuance of the book he abstained from sexual intercourse with his wife for 4 months or more. So next ground is jihar, also known as the unlawful comparison. A husband must have sound mind and above the age of 18 years to be eligible to use this mode of dissolution of marriage. If he compares his wife to his mother or any of the female within the prohibited degrees, the wife has a right to refuse to have sexual intercourse with him until he has performed penance. So essential of jihar are: the husband must be sane and adult. He compared his wife to his mother or any other female within the prohibited degrees. Then the wife has a right to refuse to have sexual intercourse with him till has expiated himself from penance prescribed by the law, which are the freeing a slave, fasting for 2 months, or feeding 16 poor person. So next, divorce by wife. There are only one mode, that talaqul tawfiz. A Muslim wife can institute a divorce by talaqul tawfiz. A husband may either himself repudiate his marriage or delegated his power to his wife, such as a delegation of power is known as tawfiz. An agreement made either before or after the marriage, providing that the wife would be at liberty to divorce herself from the husband under certain specified conditions, such as case of the husband marries a second wife or fails to maintain her for a specified period. It means when the wife uses her delegated power given by the husband to divorce himself from marriage. Next, divorce by mutual consent. The ground is khula and mubarat. Let khula, also known as divorce by purchase. So khula is a divorce which mutual consent at the instance of a wife, in which she agrees to give some consideration to her husband. It basically redemption of the contract of marriage. Essential, there must be an offer of divorce from the wife. The offer must be accepted with the consideration for release, and the offer must be accepted by the husband. Next round, mubarat, divorce by mutual agreement. So it signifies mutual discharge from the marital tie, the most essential element that the mutual consent of both the partners is required in regard to the dissolution of marriage. In the mode of divorce, offer can made from either of the side. Acceptance of the offer make divorce irrevocable, and iddat is necessary this kind of marriage. Divorce. So next, divorce by the judicial decree. The lian, false charge of adultery. This ground, lian can simply be described as the wrong charge of adultery on wife by her husband. Whenever a husband imposes a false adultery charges on his wife, then the wife can sue him and can also obtain a divorce on the same ground under the Act by filing a regular suit for dissolution of marriage. So next ground is faqs. Under a Muslim lady can approach to the Qazi for the dissolution of marriage. Quran says that this is the duty of the husband to give proper treatment to his wife. The wife is also under duty to obey all the lawful orders of her husband. If the husband and the wife both comes to the conclusion that they cannot live as husband and wife, they can refer to the matter to the Qazi, who can after careful examination terminate the marriage. And the last ground is the Dissolution of Marriage Act 1939. here the under section 2 of the act, ground for the divorce available to the wife. Here only wife can seek divorce under this ground. First, absence of husband for 4 years, failure to maintain the wife for 2 years, imprisonment of husband for 7 years, and failure to perform the marital obligation for a period of 3 years, impotency of husband, insanity and vulnerable disease for 2 years. The marriage was solemnized before she attained the age of 15, and cruelty of husband. And last conclusion, thus there are the types of talaq and the rules and explanation related to them. The main objective of talaq is to find most possible way for the husband and wife to live together, not the end their marriage life. It gives example time for the couple to resolve the matter. There is a saying, time will answer everything, and time is the best solution to solve the problem. So hey, this is the topic talaq under Muslim law I discussed. So thanks for watching.